So let me ask another question here, because we talked about Mary Brown and her not getting, submitting fraudulent signatures. You talked about her a little bit. I think you alluded to this. Her fundraising. She was a write-in candidate. She was raising funds before she was allowed to be a write-in candidate.
Yes.
I filed an ethical violation, a complaint with her with the Texas Ethics Commission, because to me that is a blatant violation of the Texas election code. There were $32,000 given to her by law firms and attorneys and so on. By June 30th, more came in after that before she was actually declared candidate. I have a couple of questions. Number one, I'm very disappointed, honestly, that the Texas Ethics Commission is not going to make a decision about this until December at their next meeting, because you and Michelle, who played by the rules, are now at a disadvantage. I think that that's cheating. And the second thing is, I think that like when you go into a courtroom, I know you need to raise funds, but I almost think like the race car driver, they should have sponsorships on their robes so that we can know who's purchased them. Well, let me ask you the question differently then. Do law firms give money to judges to purchase them, to get better treatment in front of them, to file more motions in front of them, to make more money when they're in their courts?
The attorney and the law firm are going to be on a supporting list, okay?
Okay.
And those attorneys and law firms do that for a reason. Okay?
Thank you.
Okay?
You're confirming with that.
Now, although they support the candidate, right?
Yes.
The judge is not going to make a decision contrary to the law, contrary to the best interest of the children, contrary to a just and right division of the estate, or any of that, because a law firm donated to him or her. That is the ethical standard.
That is the ethical standard. Okay, good. I'm glad you clarified that.
Now, I'm going to tell you something else, Jeff. I funded my campaign out of my pocket.
Yes.
Okay.
So you're not purchased.
So
wait a minute. You could just put Earl Jackson.
I can put Earl Jackson right here.
Okay.
I got about 22 at this point into this game.
Okay.
And I got a lot of, and they're all reported to the Texas Ethics Commission. Got all their names, all the addresses, all the stuff. A lot of donations to help. Nearly enough, but and 2 or 3 at 500, 2 or 3 at 1,000, and a bunch at, let's say a bunch at $50 or $100 or $10, that kind of thing. And all of which has to be tracked for the Texas Ethics Commission, right? And all of it has to be submitted to them.
Right.
So,
but still de minimis.
That's why we have treasurers on the campaign who do that.
Yeah.
But you're right. Just because I've been doing this for years. Just because a law firm or lawyer gives money to a candidate does not mean they get special treatment.
So now,
whether that's the reality in every court, that is the reality in courts, that is the reality. It's going to be the reality. I can give you a list of names. I won't do that, but I could give you a list of names. Well, that is the reality.
So what I've said is
in other courts, not so much.
I hear you, but now there was a study done, a friend of mine, and he did some studies about law firms, attorneys that gave money, and how if you could see the direct correlation between more motions that were allowed by that law firm, not necessarily perverting justice, but motions equals money. So I get $5,000 right now, and if I get to do 7 motions versus 2 motions, that's more money for me. So one case, I could maybe recoup all of that. I mean, it is what it is.
A motion practice. Motion practice means you got to have, you're asking the court to do something or not do something. So that's what a motion practice is. The most common motion is a motion to compel, and that's because the attorney on the other side on behalf of their client did not properly answer the discovery that was issued in the case.
Yeah.
Okay? A lot of people throw in lots of objections, lots of boilerplate objections, and the Supreme Court has tried to change that with their amendments to the discovery rule 2 years ago. Okay, which now creates mandatory disclosure. No more objections. Okay, so I file a motion if I have to have the motion. It's necessary to get a decision before the court, right? But I have seen a great many frivolous motions in the past. I have been served with frivolous motions and had to answer them and had to go to the courthouse and had to wait for the hearing and wait for the case to be called. Sometimes the case gets reset again. So, and that is very, very expensive for the litigant. It's very expensive for a party to do all of that. They have to defend that kind of thing. So,
should the opposing attorney have to pay for frivolous motions then?
Texas Rules of Civil Procedure Rule 13 says that they should. It's under whether the court decides to do it or not. Very often they will say, we reserve the awarding of fees to the conclusion of the case of trial. Texas Civil Practice and Remedies Code, Chapter 9 and 10, both address frivolous pleadings and motions. And I have seen a motion that takes up all those rules and statutes. It goes all the way down. He did this, boom, boom. He did this, boom, boom, boom. So.